I'm here to share my knowledge on the topic maintenance under Hindu Marriage Act 1955. Maintenance as a concept when considered from the point of view of law refers to the kind of financial assistance given to either of the litigating parties on application made by them, and only through an order passed by the court having jurisdiction to do so, and upon the execution of decree in this regard. It is often referred to as alimony or kind of monetary support from the spouse. Maintenance is an act of bearing the financial expenses or reducing the burden of the spouse whose economical position gets materially changed on the passing of the decree of divorce. Maintenance is the financial support that the spouse needs to pay to the other spouse on a monthly basis or in a lump sum so that other spouse can avail the basic amenities of life such as food, clothing, shelter, etc. In addition to the basic amenities, the concept of maintenance aims at putting the spouse back to the same position of comfort and lifestyle as the spouse was at the time when his or her marriage existed. There is no fixed amount of maintenance that the spouse is liable to pay to the other spouse, and it is upon the discretion of the family court to fix it. Each community has its own personal laws derived from religious scriptures, customs, and traditions. Thus, the grounds in which the woman can seek divorce and alimony may not be same for every community. Similarly, the law on alimony and maintenance also vary from personal law to personal law. For example, under the Hindu Marriage Act 1955, both the husband and wife are legally entitled to claim maintenance. However, if the couple marries under the Special Marriage Act 1954, only the wife is entitled to claim maintenance. When a couple is divorced by mutual consent, the decision of whether any alimony or maintenance is to be paid by either party is a matter of agreement between them. In such cases, alimony and maintenance could be paid either by the husband or wife, subject to the mutual understanding between the couple. In contested matters, the court intervenes and decides the amount of alimony and maintenance. The Hindu Marriage Act came into force in the year 1955 and applies specifically on individuals who are Hindus, including Sikhs, Jains and Buddhists, and persons who come under the ambit of Section 2 of the Hindu Marriage Act 1955. Also, children whose either parent is a Hindu, Sikh, Jain or Buddhist are brought under the same religion will also be considered as a Hindu and will be entitled to maintenance. A Hindu male is under an obligation to maintain the following person: his wife, unmarried daughter, legitimate sons, illegitimate sons, aged parents. After the Code of Criminal Procedure came into force in the year 1973, maintenance is now granted to wives, children and parents, irrespective of any religion or personal laws. Person claiming maintenance must be unable to maintain themselves. Wives and elderly parents are generally given maintenance. The mere fact that the wife is earning does not disentitle her from claiming maintenance. The question is whether she is able to maintain the same standard of living that subsisted prior to the neglect or divorce with her own earning, without having to depend on another. Hence, it has provided for a better status to women by granting rights in a dignified manner. The relevant provisions which governs the maintenance of spouse under Hindu Marriage Act 1955. Section 24 of the Hindu Marriage Act 1955 deals with maintenance pendulite and expenses of proceedings. The object of this section is to provide maintenance pendulite to a party in a matrimonial proceeding, if necessary to provide financial assistance to the indigent spouse to maintain herself or himself during the pendency of the proceeding, and also to have sufficient funds to carry on the litigation, so that the spouse does not unduly suffer in the conduct of the case for want of funds. The provisions is to be applied at the discretion of the court, having regard to the facts and circumstances of the particular case. The Marriage Laws Amendment Act was introduced in 2001. This amendment inserted a proviso in Section 24 of the Hindu Marriage Act 1955 which aimed to fix the duration of disposal of the application of the expenses of the proceeding and monthly sum during proceeding within 60 days from the date of service of notice on the wife or husband, as the case may be. Section 24 is not violative of equality provided under Article 14 of the Constitution. In the social structure of the Indian family, the husband is legally, morally, and socially duty-bound to maintain his wife, if she does not possess sufficient means to maintain herself. The application filed under Section 24 of the Hindu Marriage Act cannot be rejected on the ground that another application earlier filed under Section 125 for maintenance was rejected. While the proceeding under Section 9 of the Hindu Marriage Act is pending in trial court, the spouse under Section 24 of the said Act is entitled to file an application for grant of maintenance pendulite. The earlier decision under Section 125 CRPC is no bar in deciding the application under Section 24. As decided by the Supreme Court in Noor Sabah Khatun vs. M.D. Hussain, maintenance under two parallel legislation can be granted simultaneously for the reason that the Parliament is always aware of all the laws passed by it and any subsequent legislation without expressly or impliedly negating the previous one is to be read with the previous legislation. Also, all beneficial statutes are to be interpreted liberally so as to provide maximum possible benefit to all possible beneficiaries without causing any violence to the language of the statute. Section 25 of the Hindu Marriage Act 1955 deals with permanent alimony and maintenance. It comprises of three subsections. Subsection 1 deals with the conditions where any husband or wife may apply for the permanent alimony or maintenance at the time of passing the decree or at the time of subsequent thereto. This subsection empowers the court to order the respondent to pay the maintenance and support such gross sum or the monthly or periodical sum for a term not exceeding the life of the applicant. In subsection 2, the responsibility of the paying spouse ends on the remarriage of the other spouse. The court fixes the amount of permanent alimony and maintenance, keeping in view the respondent's own income and other property and the income and other property of the applicant. The court may, if necessary, also secure the payment of the permanent alimony under this section. In case the court is satisfied that there is a change in the circumstances of either party, In this condition, the court may, at an instance of either party, vary, modify or rescind or any such order in such a manner as the court deems just. Subsection 3 of this section empowers the court to rescind the order of the payment of permanent alimony if it is satisfied that the party in whose favor an order has been passed under this section has been remarried, or if such a party is the wife that she has not remained chaste, or if such party is the husband that he had sexual intercourse with any woman outside the wedlock. Basic principles considered by the court. The court acts in accordance with sound judicial principles, and it cannot act in an arbitrary manner to the prejudice of either of the parties. Main purpose of granting maintenance is to maintain the standard of living of the spouse in accordance with the status prior to separation. It is granted during the proceeding of decree or after the decree of divorce and ceases to exist on the death or remarriage of the decree holder. The spousal maintenance is determined on the existence of various factors by the court as follows. First, no separate source of income. The most important factor to be considered before granting maintenance or alimony is to check whether the spouse seeking maintenance has any separate source of income or not, or is solely dependent on the income of his or her spouse. Second, standard of living of both husband and wife before separation. Third, expenses required to maintain children. Fourth, position and status of the parties. Fifth, number of persons opposite party is obliged to maintain. Sixth, income of opposite party. Seventh, income of the claimant. There are basically two types of maintenance. First, temporary maintenance. Second, permanent maintenance. On consideration of factors by the competent court, maintenance can be granted on the following basis. First, temporary maintenance. It is also referred to as maintenance penduli, which is awarded by the courts during the continuation of proceeding of the divorce. The purpose is to meet the expenses of the spouse who is the party to the proceedings. On satisfaction, the court may grant it. Section 24 of the Hindu Marriage Act 1955 deals with this kind of maintenance, and further it can be claimed under Section 125 of CRPC. Permanent maintenance, as the term suggests, it refers to the granting of a sum on a periodical basis or on continued basis once the proceedings have been disposed of. Section 25 of the Hindu Marriage Act 1955 encompasses this concept. Either spouse is entitled to receive it, and these payments stop with the death of either of the spouse. Under the Hindu Marriage Act 1955, both the husband and wife can ask for maintenance, but it is usually the wife who gets the maintenance from the husband. But there have been cases where the courts has ordered the wife to pay maintenance. For instance, in case of a husband's physical disability that prevents him from earning. There is no straitjacket formula to decide the amount. Generally, it's 1/3 to 1/5 the gross income of the spouse who has to pay when it's lump sum alimony, and not more than 25% of the husband's salary as a monthly maintenance. If wife is earning and there is a substantial difference between her net worth, her husband's net worth, she'll still may be granted maintenance with the same living standard as that of her husband. Quantum of maintenance. The following are the documents relevant for the court to decide application for maintenance. First, income tax return. Second, Form 16 and Form 12BA. Third, appointment letter. Fourth, cost to company certificate. Fifth, salary certificate. Sixth, bank statement of all the bank accounts. Seventh, credit and debit card statements. Eighth, title deed in respect of immovable property. Ninth, registration certificate of vehicle. Burden of proving the income. The monthly income of the spouse may not be very often be within the knowledge of the other spouse, particularly in a case where their relationship is considerably strained and the spouses are living separate from a considerable period. The assets, liabilities, income and expenditure of the parties are necessary to be determined, not only to fix the maintenance under Section 24, but also to determine the permanent alimony under Section 25 of the Hindu Marriage Act and right to the joint properties under Section 27 of the Hindu Marriage Act. It is therefore necessary to formulate a format of the affidavit of assets, income and expenditure and also specify the documents to be disclosed by them. The court has discretion in the matter as to from which date maintenance under Section 24 of the Act should be granted. The discretion of the court would depend upon the multiple circumstances which are to be kept in view. These could be the time taken to serve the respondent in the petition, the date of filing of the application under Section 24 of the Act, conduct of the parties in the proceeding, amendments made in the application and the reply. Conclusionary remarks. India as a country and community take much pride in the fact that our families always stick together. Divorce rate in India is very low compared to the Western world. However, that does not mean that every wedding leads to a happy marriage. Several spouses tend not to end the marriage because of the fear of becoming financially unstable, the fear of not being able to sustain oneself and one's offspring leads to continuation of unhappy marriages. The right to maintenance is very well developed as a law in our country, and it is essential that the general public, especially the economically downtrodden class, is made aware of this provision. The institution of family is well protected by the law even if it fails to protect itself.